unaware of any of the things she just said. So,
What do you mean?
that
they couldn't do it?
yeah, they didn't tell me anything. So, I don't know the math they were doing there. But I can propose a new payment plan since they didn't say anything. I had just came up with a new one. So I got a lot of things going on in the background. And I'm actually going through bankruptcy. So
Well, why don't you tell me what you think you can do?
Or move by July 10th, 2026.
July 10th?
Yes.
Oh. Folks, is that what you agreed to?
Yeah.
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 What? All right. What's up?
We're just hoping July 10th is going to give us enough time to get another paycheck and,
Yeah.
get everything arranged stuff properly.
Like,
Miss White, you look like you have something you want to say to me. What do you want to say to me?
like I feel like we would have been able to pay off our debt initially, and we had a payment agreement like set up. But then there was like a fire at my work, and it like took me some time to like get into a different. I work at Burger King, different Burger
Okay.
King, and we were doing good on our payments. And then out of nowhere, we get like a bill for like 3 months worth of electricity. And then like a month or two later, we get another bill for like 3 months worth of electricity, which also triplicated or like it tripled each month too. So like the one bill ended up being like grand out of nowhere. And although it is a little bit of a mistake on our part, because I guess we were supposed to put the electricity in our name, although I almost could have swore that they told us that we were paying them for the electricity, but that part was still my fault. But like it took
All right, look,
like
hang on.
it took like 6 months for them to like discover that it like I don't know, the numbers are just weird, but sorry.
No, I asked you. That's okay. Um, I realize they gave you extra time, but are you guys gonna be able to do this or?
Yeah, we should.
Miss White, listen.
Sorry.
No, don't be sorry.
Appreciate your thanks.
Do you know what you do if if you're not able?
Before we moved into this place, we were like homeless for a month. We stayed at a campground and that worked out pretty well.
Okay.
They had all the basic amenities and stuff.
We're not,
Signed the first lease. We were told that we would be immediately available to the apartment that we were moving into. And then when we signed it, we realized that it wouldn't be available for another month, and that's where we had to stay at the thing.
We thought we weren't going to be able to get in because we had to spend the money that we had saved for the deposit on staying at the campground and rides to and from stuff like that. But they were nice enough. They said we could pay like half the deposit up front, and we did. And then we moved in, and we were just going to pay everything back. But then so he had two jobs before we went homeless, and then when we were homeless, like I worked a job and then he worked a job, and we have dogs that have like separation anxiety, so like one of us kind of had to be at the tent at all times. So like when he would work I would stay, and then when I would work he would stay. So like he couldn't work the second job, which was in
that's why. It's okay.
but it was the business down in the building below, well, same building, but the business below us. And they strung us along for like a month and a half saying like, oh, we're going to put you on the schedule next week. We're going to put you on the schedule next week. And then they never did. And so we fell behind. And then eventually he got the opportunity to pick up more hours at his other job. But then as soon as he got that, a fire happened at my place. And then that set us behind even more. And then we got all the electricity bills that don't make any sense. And
Okay, that's why, no.
sorry.
No, you got all kinds of things flying around in your head, trying to figure out how. Let me ask you a question. Mr. Card said, we agreed on the 10th, hoping that we can get all of this sorted out by then, right? That's what he said, and that's what you said. How much more time do you need to try to be comfortable? You think that you can get this paid?
Um, oh, what do you think?
Maybe weeks, you know?
An extra week?
Yeah. Maybe an extra week, you know?
Like I get paid weekly and he gets paid bi-weekly.
So if you head to the 17th, you think you can get this done?
It'd be a lot easier, yeah.
Yeah.
Because this way, July's rent doesn't click into it. So
Yeah.
I will issue this judgment by consent
Thank you, Your Honor.
Thank you.
for the amount that is agreed upon by the parties. I will, however, not issue a writ in this case until July 17th. So I'm going to extend the date one more week out. All right. Then that way, maybe that gives you a little bit more time to just get it together. A week, you'll be in that same month. A week is not
Yeah. It'll help out a lot.
going to help you out. Okay. And if you were explained your 3-day right of rescission,
Oh, yes.
you were explain that. Okay. You do have any questions?
No, Your Honor.
All right. I'll sign the judgment and then you guys do me a favor. All right. And that is, I know it's hard. Have a good weekend. Keep smiling. All right, Miss White.
Thank
Appreciate
you.
it.
I appreciate it.
All right. Take care.
Thank you for your time.
Might as well call all of these ones. Ram Partners versus Brown, Ram Partners versus Robinson, Ram Partners versus Sampson, and Ram Partners versus Fry. Oh, there she is. How are you, counsel?
Good afternoon, Your Honor.
Just so the court's aware, we do have a conditional dismissal with Mr. Fry.
On who, Mr. Fry? All right, let me separate that one out. You guys can all come up. All right, Ram Partners versus Fry.
Dana Hall,
sir.
on behalf of Bramford.
All right, you go ahead.
Mr. Fry and I spoke, we agreed to a conditional dismissal with the payment plan.
Okay,
Agreed that the past due rent at this time is $3,848. The court costs are $175 for a total of $4,023. Fry will pay $300 on 26th. July 1st, he'll pay $500. And then beginning on July 10th, he'll pay $700 every Friday, and those payments will stay the same, and July rent will become due, August rent will become due, so he'll pay his last $700 on August 14th, and then the following week, August 21st, is $23. So I drew it up on my laptop and he's looked at it.
your name?
Michael Fry.
And all of that is correct?
Yes, sir.
Do you have any questions regarding that conditional order dismissal?
No, I do not.
You understand that if you default upon it, that they could request of the court a judgment as well as an order of eviction at one time. You
Yes, sir.
understand that? All right. Any other questions?
Hopefully it'll be done with in August.
It's all gonna work out.
Will.
All right. Then I will indicate this case is conditionally dismissed, and once it comes across my desk, I'll sign.
Thank you, sir.
All right, thank you. I do have to tell you, you do have 3 business days to think about it from the date of my signing.
Okay.
You believe that there's some right you didn't assert, some misunderstanding, some confusion on your part, you'd have to file a motion with the court. Doesn't mean I'd grant it, but you have that time to file the motion. Got it? All right, take care. Have a good holiday. All right. We got the rest of you guys. Hold on, I'm missing one.
Where's she?
Where is she?
Who did you bring?
Miss Brown? She didn't check in? All right, well, where's the baby?
Right.
That's what, I don't know, we need her here, but I think we need, all right, well. No, which is, okay, we'll figure that one out. Where are we? Where are we on these cases?
Well, Your Honor, that was, documents Miss Gordon Lehman might have sent to the court.
You sent us something, Miss Gordon Lehman?
I did not send anything to the court. No, Your Honor.
So it is essentially a timeline showing a continuity of rental obligations because there was never a gap in the certificate of compliance. And she made a handy.
So in their building, there was never a gap into certificate of compliance where these 2 reside, or all
Correct.
3?
Correct, Your Honor. And so we provided a chart to sister counsel just to kind of give some clarity. If the court did have questions after it was resolved, whether or not any monies were owed, and if the question of whether or not there was a gap, we were able to provide some substantive information on that. But I've reviewed all the court orders regarding the issuance of the COCs and the TCOCs. And if Your Honor would like, I can run through just the very quick timing of it so you kind of have an idea.
Yes.
So the court in the circuit court case entered an order requiring the issuance of TCOCs on October 3rd, 2025 for 720 Green and 721 West Clark. And the city physically issued those TCOCs 3 days later on October 6th. Notably, the orders that the court entered required that the rental obligation be reinstated effective immediately. From that point, there was discussions with the city to extend TCOC timings in November 30th, 2025. Those TCOCs were extended to December 1st, 2025. And then from that point to the next hearing we had with the court was December 29th, 2025, and the court began ordering that the clients could begin putting people in those buildings and continue to put people in those buildings. So at all times, the court was allowing folks to be moved into those buildings. There were orders being entered by the court expressly permitting that occupancy could be allowed in those buildings. And that was starting in Arbor 1 in December of 2025. In February 4, 2026, that is when the court entered a similar order allowing occupancy to continue in Arbor West. Those 2 orders in December and February were the vacate orders that the court entered. So essentially, that's when she ordered all of those buildings to be vacated. And in those same orders, she expressly permitted people can leave the property or they can move to these buildings. Because she was allowing occupancy, everything was, running as normal in those buildings. And then finally, February 19th, 2026 is when the final COCs were issued, both for 720 Green, 721 West Clark. And at that point, we got a third COC for 721, 723 Green. That building never had a TCOC. It was always just the final COC that was entered. And then from that point on, February 19th, when they were issued, COCs have been in place in all 3 buildings. I'm not sure the timing upon which the claims of non-payment are. I can let Sister Counsel maybe establish that more, but all of our records and orders from the court have an ongoing rental obligation since October 3rd, 2025 for 720 Green, 721 West Clark, and then from February 19th, 2026 for 721 and 723 Green.
Okay. Give me that date again. Continuing rental obligations from,
October 3rd, 2025 would be the start for 720 Green and 721 West Clark. And then for 721/723 Green, it would have been February 19th, 2026.
got it. So that's probably within where our problem, thank you, counsel, where our problem may be. On the complaint, and if I just take Ms. Sampson's case, rent is being charged. Her rent was paid through February 28th, 2025. She's at 6,000. But does that rental obligation go prior to October?
So. I need to look, the ledgers, this ledger, stamp begins in April, but are these?
In April of,
So the balance starts April 1st at 11:48.
11,
48.
$1,148.
That's the point. So then there's, I didn't know what these charges were right on it. $40 water, gas 30, trash 10, big goods. So it's 1148 plus, basically it adds up to $1,281.
So the monies that are on this complaint are only from the time Ram took over? Is that right?
Well, that's what I was calling. Listen, we don't know what it is. Because this is small.
I have the Beal one and then I have theirs. I also would be wondering if, I know there was supposedly an agreement between Bill and some of the residents where they, that's the other thing.
Right, that's part of the other problem. Part of the other problem is Beal said they do something, but then you guys take over. And I don't think you guys knew anything about what Beal had agreed with them.
So. The ledger from Beal. It's like it begins October, begins October 2025, the amount of $1,231. So she had been, according to the ledger, being charged $1,231, and then she got a credit of $8,617 on October 6th. Just over rent. They had been accumulating rent, and then they wiped it clean starting October 1st. It's just over rent beginning October 1st.
So this figure that you have her owing, we'll just use hers right now. Is that amount the amount that's accumulated since Ram took over
No, this begins in October
of,
2025.
but your understanding was what?
Oh, $7,000 in
that's my first time hearing it. I got a credit. What did credit for what?
You were supposed to get $7,000, basically a credit, but on,
That I paid,
pardon?
from the rent that I was paying, non-compliant. Cause I paid from September to February. And that's when they had me to renew my lease. While
September to February of
2014.
20, started 24.
All the way up to February.
Gotcha.
When they had me to renew a lease, Barbara one did. I kept that in my purse.
I gotcha. I gotcha. Yeah. So I think, and I bet you I'm gonna hear the same thing from Mr. Mr. Goings and Miss Brown. I think one thing that you're gonna be stuck with is this. Outside of the court proceedings, because I found this on some other cases. Outside of the court proceedings, Beal made an agreement with these folks. And that was an agreement for what they paid when these units may have not been in compliance. Problem is, I believe those agreements were probably made. Nobody knew. It probably was not written down. But I don't know that I realize these are rental situations, but these are going to be a little bit different. What's clear to me is these folks relied upon that.
Well, I guess I'm trying to understand. So according to the timeline, there was always a certificate of compliance beginning in October 2025. That's when the rent began. So is it
No, there's a period before that period that she's paying rent that they're giving credit.
Credit, I didn't know about a credit.
she was given over $8,000 credit
How?
to the ledger. So all that rent that was accumulating every month was.
Yeah, but if you, is that a credit or did she pay it?
I think it was like my.
See, you may be calling it a credit. We get to the same number, but you may be calling it a credit. What shows up as a credit is actually her payment. It's not that she's getting a credit. Well, she's getting a credit if you want to look at it that way. But the credit is what she's paying.
I'm not understanding. So she.
Well, it's really simple. She pays for a period she shouldn't be paying for. Phil comes along and says, I'm not going to give you your money back, but I'm going to give you a credit. Well,
It's
going to be the 7,000 or whatever that you don't have to pay. Either we're going to pay it to you or it's going to come, but you don't have to pay it.
It's just they weren't owed rent during that time period. So I think I see what you're saying.
Yeah. And so I think what was happening is my suspicion is that Bill was making those deals, telling these people that, but then at some point, Bill's not there. And now here they are, trying to rely upon what Bill had told them, or trying to have the benefit of that deal that Bill made with them come forth.
So I'm on the ledger. I'm not showing any payments. This is the deal ledger, not the fair ledger. The most recent payment I'm just saying that was 2025. So essentially there was no rent due. They look like a credit. There's no because there was no rent that should have been paid on the page of March 2025 through September 20.
So what?
So the last payment from Ms. Sampson was February 2025, and then there were no payments. There's been no payments since then, but nothing was due between March 2025 and September 2025. They were charged, and then they were reversed.
Well, Mr. Goings, because you had the same type of situation, and so does Ms. Brown. So, quite frankly, what I'm going to do is, I'm just going to set these for. I now have a handle on what's here. I'm going to set these for final settlement conference, and then if we have to have a trial on the issue, we'll have a trial on the issue, and then I'll just listen to everybody and I'll make my decision because I'm just going to let plaintiff know. Whether right or wrong, from a calculation standpoint, there were a number of tenants where certain things were said and done and representations made to them. And may or may not know about it, but then I'm gonna hear testimony from them as to what that deal was, and then that. And I get one, it might have to be an agreement in writing, but certainly there can be other theories of representation and their reliances on those representations.
So, just so that I can have a better understanding, what time period are the defendants saying that told them there wasn't going to be a credit? What is the same time period? There was no certificate of compliance? Was it stuck from October to now?
See, hold on. You keep saying, and I just don't want to get language mixed up. You keep saying credit. That's not how it was told. How it's told is they were supposed to get money
Cash.
and then move. Oh, yeah.
Well, that the only I looked through first, so the court's aware that some of them do.
Go ahead, Ms. Gordon.
I'm trying to get the timing of all this as well. And so I'm not sure if these tenants are suggesting that they were supposed to get like move out agreement money. Because from the statement of, I'm sorry, the female defendant, what was
Miss
the last
Sampson.
name? Miss Sampson, sorry. It sounds like the timeline, she may be saying that she would be getting money from the time that there was no COCs and the money that was paid. That sounds like move out agreement type scenario. And so there very likely would have been communications between the property management team and tenants saying you can submit a move out agreement and receive your money back for the rent you paid if you leave the property and you get your payments. Those communications certainly occurred. That was court ordered items that were coming from the court. But they had to submit an MOA, and then there were processes that had to go through it. And they actually had to pay rent. So is Ms. Sampson saying that she paid rent sometime between September of 24 and before the certificate of compliance were in place, and that she submitted an MOA and was expecting that money? Is that what she's saying?
I don't. That's not what she's saying.
Okay, because that's the only.
Okay, I wasn't offered that.
Right.
Wasn't offered the move out package, especially because I would have moved. Because they were saying that if they owed me money, it was half of that back to move. And I'm like, why don't y'all just fix this so I can pay? And y'all keep the money if that's what y'all saying y'all want to do, but nobody even told me that. We would never.
No, I got you.
I renewed the lease. Why would they The old one.
I'm just gonna, folks, I'm gonna put this on a track toward trial. I'm just gonna listen to everybody and then I'm gonna make my call on it. I mean, I get that there were not finding this, but I am going to suspect that the agreements that are laid out in the circuit court before Judge Kunke are as counsel has indicated. But I am also of a belief that there were things said to tenants that were inconsistent with what was happening there. And I don't know where, then from the court's perspective, where that should fall. So I'm going to set final settlement conference. What's that date we have? July 14th, 2026, 9 a.m. We'll be able to sort of hammer that out. And from there, I'll set trials on these men. Okay.
And I do know that there was another one union.
Pardon?
The union that they had for all of this was on.
I know.
Have all the court documents and all of that for letters.
Right. But and I understand all of that. The problem isn't what anybody did in the other court, or what anybody did is where there was a union of the tenants coming forth and doing whatever. None of that, in my mind, is a part of a problem. It's, which is where I see this going, is what do I do? What does this court do with what may be stray representation? Arbor Woods versus Shakori Davis.
Good afternoon, Your Honor. Rachel Dornbush, Pallet Law, on behalf of the plaintiff.
Corey Davis.
And see, where are we on this? This is her motion.
It is, Your Honor, but I actually, I think we have a resolution on it. Ms. Davis and I have been corresponding via email. And assuming she confirms the terms of this agreement, I would propose my preparation of it and submission to the court.
Okay.
The agreement would be as follows. We would enter into an order indicating that Ms. Davis's motion is withdrawn and the writ is stayed on the following conditions. There's $6,200 in escrow that would be released to Arbor Woods. Ms. Davis would pay $800 on or before July 3rd. And Ms. Davis would pay she's anticipating, Your Honor, $3,000 from Friend and Deed. And assuming they pay the $3,000, that would leave a remaining balance owed for July in the amount of $1,140.67, which Ms. Davis has indicated she believes she can pay on July 7th. Then the order would indicate that the Friends and Deed payment, we would put a deadline on that of like July 17th for that to come in. The understanding is that as soon as she pays the $800 on July 3rd, they're going to process payment to release to Arbor Woods for the $3,000. So that gives a few weeks for that payment to be mailed over to Arbor Woods. If all of those things happen, that would then settle Ms. Davis's balance through July. The balance with the July charges, Your Honor, $11,140.67. Putting all of those things up, that would get her to that balance. If there was a default on the agreement, plaintiff could proceed with the order of eviction by filing a notice of default with the court, setting forth the nature of the default.
All right. And so this is, in essence, You said at the beginning, because this is her motion.
It's her motion, Your Honor. So, I mean, I
Okay.
would treat it as, I think I've phrased them before, an order regarding payment on account, and withdrawing defendant's motion.
All right, good enough. Ms. Davis,
Yes, sir.
is all of that correct?
Yes, it is. We've been talking email. She said exactly everything we discussed in the email.
All right. Okay, very good. Then I will await the paperwork on it. I will sign off on that. I will order, even before getting the order, understanding what the parties are trying to do, I'm going to order the release of the escrow to the plaintiff now. Okay, is that okay with you, Ms. Davis?
Yes, it is.
All right, fantastic. Okay, thank you guys for working it out. Ms. Davis, have a great weekend and a good holiday.
Thank you. You all have the same.
Thank
Right.
you.
Arbor Woods versus Lakeisha Sanders.
Yes, it is.
Afternoon, JudgeSimpson.
Sanders, how are you?
I'm good.
And let's see, where are we on this one?
Your Honor, I've got a balance due $2,532. Looks like there was a payment made on June 12th of $884.74. Though I know Ms. Sanders had indicated she had intended to pay minimally $2,000 by today. Ms. Sanders, did you pay anything else to management? If so, I can verify with them.
Pay it all.
You paid everything? Oh, she just sauntered up and then just did that. So when did you do that? What day?
Yesterday, like I said.
Well, you told me you were going to pay 2,000, so that's the whole thing.
I paid
All right.
$2,590.
How much?
$2,590 because they add $10 per money order and
Got
they
it.
added a $30 late fee on June 21st.
Let me. Does your client indicate that they have that?
Your Honor, if we could pass on the matter briefly, I'm going to check with them.
Okay. She can have that back. All right. All right, let me pass on that. They'll let me know right away. All right, thank you, man.
You're welcome.
Court does call the case of Arbor Woods versus Shanice Alexander.
Hi.
Hello. I think I'm okay. Okay, where are we on this case?
Your Honor, we've got a balance of $3,269.55. Your Honor, Ms. Alexander had proposed a payment arrangement, my client, which I think she had somewhat presented in court last week, that my client was unable to approve, as it would take approximately 9 months for the balance to be paid. And that's unfortunately not something that they're able to agree to.
Interesting. I was unaware of any of the things she just said, so.
What do you mean?
That
they couldn't do it?
Yeah, they didn't tell me anything. So, I don't know the math they were doing there. But I can propose a new payment plan since they didn't say anything. I had just came up with a new one. So I was.
Well, why don't you tell me what you think you can do?
Oh, okay. So I was going to try to pay, what I was going to do is try to pay July. Well, my proposed plan was $1,000 every 2 weeks because I was waiting for some money from school because I usually pay it up with my school check until then to pay it up. But if they don't like that, I had a backup payment plan of paying July 1st, paying on time, and then can follow up with $1,000 every 2.
Okay, let me ask you this. When's your school money come into you?
It don't start till June, fall semester, late June, early August.
Oh, you mean late July August.
Yeah, that's what I mean.
Okay. Oh, boy.
So I got a lot of things going on in the background. And I'm actually going through bankruptcy, so I don't know. I talked to my attorney about interceding or talking to them on my behalf, and he hasn't really gave me an answer quite of yet. But yeah, that's why my money is a little funny, because I got things going on in other courts that I'm working on.
Your Honor, if I may just ask, if Ms. Alexander has already filed the bankruptcy.
Yes.
They have.
Ms. Alexander, do you
Yes.
know by chance what your case number is? If you don't, that is just fine. Your
don't.
Honor, if she doesn't, then I would propose we can set this one over to July 10th. Let me look into that. And we can figure out where we need to go from there. But I need to verify the status of that case before I can make any decisions.
Okay.
July 10th, 2026 at 12 noon. Okay.
Okay.
All right.
All right. Thank you.
You.
Have a good day.
Arborwood versus Shaitan Campbell. Oh, hello. What's your name?
My name is Shaitan Campbell.
And I guess also Day. All right. Where are we on this case?
$3,144.79. Though at the last date, Ms. Campbell indicated an intent to pay by today. So if she did, I can verify with management.
Did you get it paid?
No, sir.
Okay. What happened? You paid.
No, I won't get my check until tonight. It won't hit my account till tonight.
Pardon?
My check won't hit till tonight. It won't hit my account till tonight.
Okay. So when it hits your account, you can pay the entire balance?
Oh, I will not be able to pay the entire balance like I thought I would be able to, because I wouldn't be able to put in a hardship for my 401k to July 1st.
Okay. So when the check hits tonight, how much are you going to be able to pay?
My check, I could give $1,500.
And then July 1st, you'll be able to pay, or you'll be able to do a hardship.
I'll be able to do the hardship.
Okay, so here's what I'm going to do. Find no tribal issue. That amount was it 31.44?
And 79 cents.
And 79 cents. I'm going to issue a judgment for possession in that amount. Okay. And then I'm going to extend slightly the writ date to July 10th. Okay. 2026. So what that does is you get the 15 in. If you file your hardship on the 1st, I'm not saying that everybody's going to operate like they should, but if you file it on the 1st, they should be able to give you an answer in 10 days, and then you can get the rest of it to them.
Yes.
That's my thought.
Yeah, that's
okay.
I agree.
Okay. And understand none of this includes your July rent.
Correct.
Okay. All right. Thank you.
Have a good holiday.
Same. Arborwoods versus Carrie Lee. Miss Lee. Oh, there she is.
I'm here.
Okay, state your name again.
Shakari Lee.
All right. Where are we on this case?
Your Honor, I believe we've reached terms for a proposed consent judgment. With respect to Ms. Lee, we would request entry of a judgment with the same terms as to defendant 2, Ms. Page, as I don't believe she's present.
Yeah, she is.
Currently, Your Honor, there's a balance of $3,508.42. That balance plus the July rental charges will be paid as follows. Ms. Lee made a $600 payment today. It is being processed. It might technically be tacked onto the ledger. I'm not sure. But nonetheless, it indicates in line 10 of the judgment that was prepared that she'd pay the $600 today. It is $850 on or before July 1st. And then the remaining balance plus the July rental charges on or before July 24th. It indicates that plaintiff may seek an order of eviction after the statutory 10 days or after July 6th if there's a default on any of these payments. And that would be issued without hearing, meaning that the 56-day rule under MCR 4.201M would be waived.
All right. Ms. Lee, is all of that correct?
Yes.
All right. Do you have any questions regarding that judgment at all?
No.
Okay. And you did apprise of her rights under the court rule?
I actually did not, Your Honor, but I'm happy to do
Okay,
so
that's
as Your
fine.
Honor prefers to.
All right. And Ms. Lee,
Yes.
you don't have a problem with, since this is a consent judgment, with Ms. Dornbush signing your name to the judgment as long as it meets the terms that we laid out?
That's correct. No.
Okay. And I do have to apprise you, you have 3 business days to think about this from the date that I signed that judgment. If you believe that there's some legal reason, some right you didn't assert, some misunderstanding, some confusion on your part, you'd have those 3 business days to file a motion with the court. You understand that?
Yes.
All right, very good. And what was the total amount that was owed? I'm sorry.
The current redemptive amount, Your Honor, this number doesn't include July. I didn't add all that in. 350842.
Thank you. Okay, very good. Thank you, Ms. Lee, for working it out.
Thank you.
All right, have a good weekend.
You too. Bye-bye.
Northville Crossing versus Rebecca White. Rebecca White, not checked in. I think I had sworn you earlier today. You may proceed.
Thank you, Your Honor. There is rent to retain of $3,758.50, cost of $192 for a total due of $3,950.50. We'd ask for entry of a default possession only judgment with writ to issue after 10 days.
Judgment to the plaintiff. That's by default for possession, redemption amount, the amount requested, writ to issue in 10 days. Paula Clark versus, Scio Farms versus Paula Clark and Anthony Clark.
Hi,
Hello.
Hello.
how are you?
All right. Okay, where are we on this case?
We've got a balance due of $2,366.89.
Okay, and folks, how are you gonna get that paid, you think?
I just sent a proof of assistance letter from the skip program to the court. She just emailed it to me, so I just forwarded it to the court that they are submitting a funding request for $2,529.58.
Okay, is that the program with the Housing
University
Bureau
of
for
Michigan.
Seniors?
Yes.
Pardon?
From
With
the
Housing
University
Bureau
of
for
Michigan.
Seniors?
It's the senior crisis intervention program. He was.
Yeah, right.
Yes.
Yeah.
Okay, and so did you have a copy of that with you, or?
I just uploaded it to the court.
She just her name is Madden. She just sent it to us maybe 15 minutes ago.
All right. And so that would cover you. And then what about July?
July would be paid by July 2nd or 3rd.
Okay. So here's what I'm going to do. I believe you guys. I'm going to adjourn this out to the 10th, 2026. We don't have the paperwork or didn't get to me, but that's okay. You just got it. So I'm going to adjourn you out to July 10th, 2026 at 12 noon. Okay. And then we'll see where we are.
Okay. Thank you.
All right. Thank you guys. You guys have a great weekend.
You too. Thank you. July 10th at 12.
Your Honor, actually, before the clerk sign off, if I may ask,
Yeah, hold on.
are they still anticipating some assistance from DHS? I know they had mentioned previously.
The Madeline was reaching out to DHS to see what they're gonna contribute, if anything, and if not, she's trying to pay the full balance through the
Got it.
other program.
Got it. Okay.
All right. Thank you, folks.
Thank
Thank
you.
you.
Scioto Farms versus Jasmine Connerly. Oh, there she
Here.
is. Hello.
Hello.
All right. And what do we have on her case?
Your Honor, Miss Connerly made $1,000 payment today. And so we've got her at $1,013.12.
Okay, we didn't quite get the balance paid, right?
I'm sorry to interrupt. I put the 1,000 on there, I believe, last week. And then today I put in another 700. So it might not be on there yet to show.
Patty, you're signed in, right?
Yep.
Yes, I'm here.
Can you clarify? I know you would.
I'm looking right now. Miss Connolly, did you drop it in the Dropbox or drop it in
the
personally?
office.
In the office? Okay.
Yeah.
Yeah, I only have the 1,000. Give me just 1 second to go check the front. Hang on.
Okay. All right, let me pass it. Hang on, Miss Connerly. I'm going to try to do some other things while she's looking.
And Your Honor, just so the court is aware, and if you want to recall since, I had a note from the last court date that Mr. Drummer intended to pay $2,000 by the 25th, but my client confirmed today they did not receive that.
All right, did you get that paid, Miss Drummer?
So I didn't get it paid because I was waiting on.
Oh, you're breaking up, Miss Drummer. You got to stay someplace with a consistent signal. Did we lose her?
Oh, I'm sorry. Hello?
Yep. Okay,
Okay.
what'd you say?
So I was waiting on Friends Indeed to tell me to give me a response because I had applied with them, but they said that they would only pay up to $500. So
Correct.
that would not really be sufficient. So what I am for sure that I can do is pay the full balance by the 29th. And I emailed the complex. I don't know who I was talking to,
Hold
but
on, the 29th of this month?
Yes, sir. Monday.
Okay. So you think you can pay the full balance?
Oh, I know for a fact I could pay the full balance. I've been living there 4 years. This has happened once before and it won't happen again.
I got
just had a bad month.
Okay. So here's what I'm going to do. I'm going to issue judgment finding no tribal issue after hearing for the 4638.98. Okay.
Okay.
And then I'm going to give you 10 days to pay that. So that's going to give you to the 6th at least to get it in. Sound good?
Sounds great. And I
Okay.
get paid. Oh, well, you didn't ask me that. Never mind. Okay.
Okay. And that doesn't include your July rent.
Okay. Well, since you said that, just so they know, I get paid 3 times in July. So before the 15th, I'll have July taken care of. And then my lease is actually up on the June 29th, but they said that they will go ahead and re-sign it if it's taken care of before June is over.
Gotcha. Okay. All right. Ms.
Sorry.
Drummer, take care. Have
Okay,
a great
thank you.
weekend.
Bye.
Bye-bye. Spice Tree Apartments versus Imbozu Lewindu. Or Lewindu, I think. I get it all. I mess it up. Hello.
Afternoon, Your Honor.
What's your name?
Bozu Duendo.
Okay, I got it. All right. Where is she on the?
$3,156.69. I had a note of an anticipated payment of $1,900, but my client indicated they didn't receive any payment.
What happened?
I had a very, very slow week with my alternate funding because I had initially anticipated a project would pay through. which I was working on in April, and that was supposed to cover May and June rent, but that hasn't been paid off yet. And I have to be patient with them because in my experience, sometimes clients will not pay if they feel like I'm being rude and pushy. So I've had to look at alternate sources, and the alternate sources unfortunately were pretty slow. But I have a backup plan, which was to ask my church for help because they have already that lifeline in case I needed it. And I figured out ask them on Sunday.
Okay. Okay. So here's what I'm gonna do so that we can at least lock the figure in. And that was 3156.10.
3156.69.
Okay. So what I'm gonna do is I'm gonna find no tribal issue. I'm gonna grant a judgment for possession. You need to pay that amount. I'll extend you out a little bit so that if your church will help you out, they can. So normally it would be the 6th. I'm going to give you an additional week to try to get it in because I realize you're working with patients that got to pay you or folks that got to pay you. So if your church does it, then great. And so I'll just extend the rent to July 13th.
Does that include the July rent then, Your Honor?
I'm not going to do that with her. I'm just going to have her do this because then I think she can get it paid. It's just people not paying her slow. From the last time that we were talking, she's just, I kind of get where she is, so I'm not going to do that. All right.
Thank you so much, Shona.
Thank you.
Have a good weekend.
Spice Tree Apartments versus Kenyatta Patterson. She's okay. She's the K. Hello.
Hello, Your Honor. I'm here.
Okay, you're here. Okay, what does Mr. Patterson know?
Your Honor, I've got him he made a $2,000 payment today, Your Honor, my client, or I'm sorry, he has since made a $2,000 payment. That would bring his balance to $1,848.69.
All right. So he did make
a $2,000 payment.
Okay, so didn't quite get to the 25. All right.
I didn't quite
say again.
I didn't mean to interrupt you, Your Honor. I didn't quite get to the 2,500, but I think I can get this. I think I can get this past balance taken care of in the next week to week and a half.
Okay. All right. That's fair enough. And you did good. You got the 2,000 in. I get it. So I'm gonna issue a judgment for possession, finding no tribal issue for the 1848.69. Okay. And you said a week and a half.
Could you give me to the 10th? So that'll be 2 paychecks for me, and I know I can take care of it in 2 paychecks.
Okay. Fair enough. Since you did the first part, I'll extend his red date to the 10th.
Thank you, Your Honor.
Thank you. All right, sir.
All right,
Take
thank
care.
you.
I don't know what you're doing, but you got that hard hat on and that safety vest, so just be careful.
Pour concrete, sir.
Oh, man. Okay. All right. You take care.
All right.
Whitaker Oaks property versus Travis Mill Spa.
I'm here.
All right, Mr. Mill Spa is here.
How you doing?
And what do we have?
Your Honor, $3,278.78.
You said 70, how many dollars?
3278.78.
Okay.
Your Honor, yeah, Mr. Millspot indicated he was going to make a $1,700 payment. I actually spoke with him about it on the 19th. He had some concerns about whether or not Whitaker Oaks would take the payment, as they had indicated they would not do a payment arrangement. He thought they meant they wouldn't take the partial payment. I assured him they would take the partial payment and to make the payment as was ordered by the court. They didn't get anything from him. So I defer to Mr. Mospa as to what's going on with that payment.
Sir?
Yeah, I was supposed to get an $850 paycheck last week between my two jobs. It didn't end up being as much as I thought it would. And on top of that, before I could get out of work on Saturday, I had some of my utilities that were on auto pay come out and actually put my card in the negative. I did just get paid today, but it's not nearly enough to cover the $1,700. I'm just not sure what to do from here. Had a lot going on.
All right. Well, Mr. Millswell, unfortunately, it's not an issue to really try in the case. So I'm going to find that there's no tribal issue. I'm going to issue them a judgment for possession.
Okay.
For the full amount of the $32,78.78. And understand it doesn't include your July rent.
Yeah, I understand that.
You got that? And I'll just extend it out a little bit. I'll extend it to July 8th. Okay?
Okay.
So give
thank
you a
you.
little bit of time to try to get that whole thing paid, all right?
Okay. Now, in the meantime, so is that my rent date?
Is July 8th.
July 8th. Okay. Thank you, Your Honor.
Thank you.
You have a good day.
You do the same. Ms. Dornbush, I think that's it.
I would have to concur, Your Honor.
All right. And I'm glad you were there so you could hear what was going on with
The one
other
case, yes, indeed, I almost interjected with some information, but Patty was also present, and so she and I have some stuff to do.
Gotcha. Okay. You have a great weekend. Good holiday, please.
Thank you. You as well, Your Honor, and to all your staff.
Thank you. All right. 14A stands adjourned.
Should a judge believe a tenant who's drowning in debt, or assume it's just another excuse? That emotional question became the center of one of the most unforgettable eviction hearings of the day. A tenant walked into court already thousands of dollars behind on rent. The landlord argued that enough time had passed and that the balance continued to grow every month. From the outside, it looked like another eviction case that would end in a judgment against the tenant. But when the judge asked the tenant what happened, the story became much more complicated. The tenant explained that she had a payment plan ready and was expecting money from school. On top of that, she revealed something no one in the courtroom expected. She had already filed for bankruptcy. She admitted her finances were falling apart and said several legal matters were happening at the same time. She wasn't asking the court to erase her debt. She was asking for a chance to prove she could recover. The landlord's attorney immediately asked the judge to move carefully, explaining that the bankruptcy filing had to be verified before the case could go any further. The judge paused for a moment. Then he looked directly at the tenant and made it clear that he wasn't going to guess, he wasn't going to assume, and he wasn't going to rush to judgment. Instead, the judge delivered a message that changed the entire hearing.